Hello, everyone, and welcome to Thursdays Live with Chug. Each week, we cover pressing topics that matter to you and your business. My name is Arianna Gonzalez, and I'm the Client Services Manager here at Chug Attorneys and CPAs. Please join me in welcoming Senior Partner and Attorney Navdeep Meamber from our Santa Clara office. Hi there, Navdeep, and welcome.
Thank you, Ariana.
So for today's topic, we're going to be talking all about obtaining a green card from your employer and the requirements and benefits of having a green card. Make sure you stay tuned till the end for our tips and tricks for those who are going through this process. So let's get right into it, Navdeep. Can you talk about what is a green card?
Green card, yeah, this is like the term, very important. The moment any person comes to the US in a non-immigrant visa, like everyone is like, okay, how can we get a green card? Because they know green card basically is going to help you to stay and work in the US permanently, and you don't have to work about extending your visas or non-immigrant status. So basically, it is also known as a permanent resident card and shows a person is a lawful resident of the United States.
Fantastic. Perfect. So document that means you're a lawful resident. Can we talk about
Yes.
the benefits of having a green card?
Yes, the foremost benefit is that you can live and work permanently in the US. You do not have to worry that, oh, we have to extend your H-1B or L-1, any of another non-immigrant work visas. Then you can travel abroad using your green card. You can even sponsor your family members as a permanent resident green card holder. And the foremost benefit is also that you can apply for citizenship. So this opens your route towards naturalization. Since we're talking about obtaining a green card through your employer, so basically it means that if you want to be citizen through your employer green card, you have to wait for 5 years. Once you have your green card in hand, maintain a residence. So there are certain requirements for citizenship that needs another session on that. Make sure that you maintain your status as a permanent resident in the US, and then you can apply for citizenship and be a US citizen after 5 years of having your green card status.
Wonderful. So sounds like peace of mind once you have that permanent resident card. So can you talk about the different categories of employment-based green cards? I know there are quite a few options out there for us.
Yes, there are several employment-based green card categories, EB1, EB2, EB3, EB4. Each category has its own specific requirements, such as work experience, education, qualifications, but these are the most common which we do for our clients.
Great. So let's get into the eligibility requirements for those different visas that you just mentioned. I know you talked a little bit about the EB1. Can you go into that a little bit and the eligibility requirements for the EB1 visa?
Yeah, so EB1 is the category of employment-based immigrant visa that allows individuals with extraordinary ability, outstanding professors and researchers, and multinational executives or managers to obtain a lawful permanent residence in the US. Since we're talking about through employer, I think I can focus more on EB1 as a manager, multinational executives, or outstanding professors and researchers. So if someone wants to get a green card as an outstanding professor and researchers, they have to meet certain requirements. They must have a permanent job offer from a US employer. Then the applicant must be recognized internationally as outstanding in their academic field. They must have at least 3 years of experience in teaching or research in the field. And the job offer which they have from their US employer must be a tenure track or comparable position at a university or other institution of higher education. So these are the main just highlights for the outstanding professors and researchers. The other AB1, which is commonly we do for our employers and clients, is multinational executives and managers. So for this, first you need to have a multinational entity, means your US employer has another entity in another country. It could be parent, it could be a subsidiary, it can be an overseas affiliate or a branch of a US employer. And then this applicant must have been employed for at least 1 year of the 3 preceding years by the overseas affiliate or subsidiary or branch of the US employer as a manager. And then the applicant must be coming to the US to work as a manager or executive capacity, okay? And the US employer must have been doing business for at least 1 year. These are the main criteria for multinational executives and managers.
So it sounds like there are quite a few requirements for the EB1 and rules that we need to follow. So don't be worried if you don't qualify for that. Let's get into the EB2 and EB3 and talk about the eligibility requirements for the EB2 and 3 visas.
So EB2 and EB3 are the, I would say, most common. People who do not qualify for EB1 outstanding professors or multinational executives and managers, they then go through the EB2 and EB3 through the employers, especially if you're working here on H1B or L1 kind of visas. This is the common route you would look into and talk to your employer about this one. So let's talk about EB2. EB2 is basically an advanced degree. The applicant must have a master's degree or higher, or they would have a bachelor degree and at least progressive 5 years of experience in their field, related field to their education. So these are the two common which we do green card 3 EB2 category. There was a high demand for EB2 past years because the visa number availability was faster for EB2s. So everyone wanted to be filed as EB2s. But recently, since last 2 years, the visa number for EB3 have been moving faster, and people have been actually trying to get filed under EB3. So what is EB3 category, right? So EB3 is that if you are a professional, so the applicant must have a US bachelor degree or foreign equivalent degree, and the job offer requires at least a bachelor degree. Um, and then they could be a skilled workers also as EB3. It means that the applicant must have at least 2 years of job experience if you're not a professional. The most common being here, especially in the Bay Area and the tech industry, which we do assist with, the common is professionals. Most of our clients, we do EB3 is they have a bachelor degree equivalent or from the US, and then 2 years experience, or it could be 3 years experience as well. And that's what the position requires. So they qualify for EB3 category. Since we're talking about EB2 and EB3, I just wanted to quickly touch on that if you already have I-140 approved through EB2, and because the visa number are moving faster under EB3, there is process called downgrading. You could downgrade your EB2 to EB3. So basically, you will have to refile I-140 again, which we'll be talking further about what is I-140. So you just need to file I-140 EB3, and then you would qualify under EB3 category as well. So it all depends on the visa number availability, which comes out, the bulletin which comes out each month, what dates are faster. So right now, a lot of our clients who had EB2 approved and their dates were not current, but their dates are current under EB3. So then we look to downgrade those applicants 485 to get so they can file 485 that way.
That's super helpful information. I appreciate you going into detail about that and the possibilities of downgrading the visa and why that's helpful for some people. So let's get into what you were just mentioning. Can you talk about the PERM labor certification process? I know we have a few inquiries about that process.
So if you want to be filed as EB2 or EB3, you have to go through this process called PERM labor certification process. So when we are talking about employment-based green card process, it's like a three-stage process. There will be a PERM, that's the first stage. Then there will be I-140, and then there will be 485. When we're talking about PERM, it's a PERM labor certification process. So employer must obtain a certified PERM from Department of Labor, which basically involves that proving there is no qualified US worker available to fill that job, and the employer is offering that position to the candidate. Just to give some more details about the how PERM process works, because that is the takes the most time, I would say, initially. Once our clients tell us, like, okay, we want to file a PERM for this applicant or candidate, we determine the position, the requirements of the employer, and then we have to file a prevailing wage with Department of Labor. Prevailing wage, basically, we give the title, the position description, and the requirements, education requirements or experience or skill requirements. And then Department of Labor comes back to us with the prevailing wage, which they think is the right for that position and for that location of work. We have to also tell where this person is going to work. Right now, the prevailing wage process is taking super long. It's like even taking 8 months plus. It's, I know, very frustrating for our clients, but it's something outside, nothing much can be done. You have to just wait for Department of Labor to come back. They're trying to expedite it, but still it's delay. It's overall long delay on that process. Once we get the prevailing wage from Department of Labor, that this is the minimum wage you can offer, you have to offer, the employees have to offer that wage for that position. Then the recruitment process starts. So recruitment process is also 5, 6 different ads have to be run. They have to run to Sunday ads in the newspaper, print ads. Then there have to be ad run 30 days minimum on the SWAs of each state. Then they have to run ad on the employer website. They have to do internal posting. Then they also have to run, normally we do in consecutive with the newspaper, like on Monster or some, like we do at least 20 days or 30 days of ad on that. So there are different ads which have to be run. The employer has to make that effort to make sure that if they can find a US qualified worker or not for that position. And if they do receive any resume, they have to contact those qualified candidates and interview them. And once the recruitment process is done, and if they do not find any qualified US worker, then only they can proceed with the filing of that PERM labor certification. And if they do find a US qualified worker who fits, who has that education requirement, who meets the skill and education experience requirements for that position, then the employees cannot proceed with the PERM. So that is the things. This is like perm takes a long time. As I mentioned, the prevailing wages are taking around 8 months plus. And after we get the prevailing wage, when we run the ad, so that's another at least 60 to 70 days takes for the ads to be run. After running the ads, we have to wait a minimum 30 days to do the recruitment and contact the candidates. And after that, only once this is done, then only they can go ahead and file the perm application. And after perm is filed, it's done online. After it's filed, it can take another 7, 8 months to get approval. And if this sometimes it can go into an audit. Audit happens when Department of Labor needs some more information. They're not satisfied, and they will come back and they will ask copies of all the resumes that employer received for this position and all the ads which were run for this position, and or any other qualifications like business necessity, anything else. They come back and ask those during audit. And also, just to be aware, in some situations, firms can also go into supervised recruitment process, means that after you respond to the audit and Department of Labor is not satisfied that the process was done in good faith, then they will tell that you need to rerun the ads. And all the resume for the position go directly to Department of Labor, and then they will forward those to the employer, and those have to be contacted and interviewed. So sometimes sperm can take really long. If you don't get an approval after 7 months, means you will take further audit and supervised recruitment, which can surely go another 2 years or so. So that's the first process, which is the perm, first stage of the green card.
That's very interesting. I appreciate you sharing all of that information on that topic and, the auditing process and the possibilities of that and how the employers have to go about proving this. So that was very interesting. Can you elaborate more on that and talk about when employers can file the I-140 petition?
So yes, the second stage of the green card through employer is the I-140 petition. It's also called an immigrant petition through your employer. Once the PERM labor certification is approved, the employer can file I-140 immigrant petition with USCIS. This is where they submit to make sure that the candidate or applicant is meeting the PERM requirements. So they submit all the education documents, the experience documents for the applicant or beneficiary, to show that they still have the job offer. They'll give a job offer letter, and also they have to show ability to pay. That's the actually most important criteria for I-140. The employers have to show the ability to pay the PERM wage, which is the prevailing wage, which we were talking about initially. Department of Labor comes back to that number amount. So you have to show that I-140 stage that the employers can meet that wage so this is shown through their federal taxes or annual report, the revenue they are making, and it has to be shown from the date of the PERM filing. So this is the continuous ability to pay they will have to show throughout the green card process till the green card is approved.
Great, that's really helpful information. So I know you were mentioning a little bit about the visa process. So can you talk about why the applicants need to wait for a visa number?
Yeah. So depending on the employment-based categories and the employee's country of origin, there may be a waiting period for a visa number to become available. This is because there are annual limits on the number of green card that can be issued on each category and for each country. Just to give an example, countries like India and China, these are the most sought after visa categories. They are like always behind. They are not the current. So people have been, I can say my clients have been waiting for over 10 years for their numbers to become current. So when we're talking about the visa number, so this is the date of the PERM filing. Uh, so this becomes their priority date, the date the PERM gets filed. So the visa bulletin for each month shows that what date visa number is available. And then if your date meets that date is current, then only you can file 485. Or if you do the consular process. So this is the most this is the last stage, but you just get stuck at this stage. A lot of our clients are just waiting for the numbers to be current. They're done with the perm stage, they're done with the I-140, and then they're just waiting for the visa number to be current. And they check the visa bulletin each month and see how the dates are moving right now. So the EB2 retrogressed and EB3 is now ahead of EB3 2. That's what when I was talking about the downgrade process that comes in the picture at this stage. So we are downgrading some cases so they can file for 85 that way because their dates are current under EB3, but they're not current under EB2.
That's interesting. So some applicants need to wait depending on their country of origin and employment-based category. That's helpful information. So while we're still on that topic, can we talk about the adjustment of status and consular processing? Can you go a little bit into what that is?
Yes. So once I-140, well, actually, when we file I-140, we have to mention in that stage that if the person is present in the US, they will be doing adjustment of status, or if they are outside the US, then they'll be doing a consular process. So when we talk about adjustment of status, means you're physically present in the US here on another visa, non-immigrant visa, and working in the US, give example of H-1B visa. So you're already working here on H-1B visa and you had your I-140 approved. And if your date becomes current, then you can file I-485. So this is like basically adjustment of status. You are adjusting your status to a permanent resident. There are certain forms which have to be filed. The applicants have to show that they have maintained their non-immigrant status throughout their presence in the US, very important. That they already had extensions done whenever needed. They were never out of status. This will be looked at this stage when you're doing adjustment of status. Then they have to submit their medical reports, and then same time they can also file for their family as well, dependents, spouse and children, and submit their birth certificates and the marriage certificates. There's a long list of documents which is needed, and that's basically filing adjustment of status. So if the dates stay current, the adjustment of status may be approved in around a year. Um, those are normally sometimes processed by the local office within the jurisdiction where the applicant is residing. They may call for an interview They used to call an interview before COVID, but after COVID, they do case by case. They may even approve without an interview, but they also call for an interview. The whole family will have to go for the interview. They just want to go over the requirements and make sure that the person has been maintaining status and the job offer still exists. There's another form, Supplement J, which has to be submitted to make sure that the employer, because the case has been pending for so long, right? They're 45 sometimes, then you have to show that the job offer is still existing for you. So that's the I-485 adjustment of status process. But if a person is not in the US, which could be that when we did your I-140, you had to already leave because maybe your H-1B already expired. You could not stay longer here. So then we will notify that this person is outside the US and he's going to do green card through consular. Or if even after we do I-140, sometimes you're still physically present in the US, but then you leave after we do I-140, right? Then this person will still go through consular process. Then we'll have to transfer your file through consular by filing another 824 and let them know that the person is not physically present in the US. And then the consulate basically goes through the NVC, National Visa. So their NVC will be collecting some forms, information, fees, and once those are submitted with NVC, the whole process is completed. Then they will forward your file to the consulate in India or China or whichever country you are from, where you're residing. Then they will basically call you for an interview. Some process has to be done over there as well. They need police clearance certificate and all that. That can take some time, and medical has to be done. So then you just have to get your green card through the consular. You will be called for an interview in the consulate, and then you will be given the immigrant visa, and you have to come within certain time to here. And once you physically land in the US, then the green card will be mailed to you later. You do not get it right when you land here at the airport. So that's the consular green card process.
That was a very helpful explanation of the whole process. So just a quick note for everyone tuning in, we are talking about obtaining a green card through your employer. And this conversation is for informational purposes only. We are live on YouTube, LinkedIn, and Facebook. This does not create an attorney-client relationship. It's just for informational purposes. So if you have any questions, please comment them below or feel free to email us at info@chuk.com and we'll be happy to help you out. So let's get into my next question, Navdeep. I know you've been doing this for quite some time. So in your experience, can you talk about the common issues and challenges with PERM and the I-140 process?
Yes. So these are the things we actually try to keep in mind when we are working on them, because we have seen these issues coming up again and again, and we want to make sure that we want to avoid those issues for our clients. Let's talk by step by step. So when we're doing PERM, we want to make sure that person has the education. If someone has a 3-year degree, that can create issues because US needs a 4-year degree. So we have to see what are the requirements for the position and how person's education can meet that requirement or not. We do need to get an education evaluation. So education is one thing to keep in mind, when we are working on those PERM, because this is critical. Then experience letters. A lot of time we see our clients do not have experience letters. Wherever the position needs an experience letter, let's say it needs 5 years of experience with certain skills or 2 years experience with certain skills. But when we work with our clients, we notice that they are unable to provide experience letters because they left those employers that didn't really get the letters from them. Then they have to go contact them and get letters. And sometimes it is very hard for them to get those letters. And also the letter have to have certain format. You need to have kind of your title mentioned in there, your duties mentioned there. If you use any skill, those have to be mentioned. Your end and start date has to be mentioned. So a lot of time we have seen that our clients have a hard time getting letters. Then there are certain ways we can make that work. If they do not have letters from their employers, then there's secondary evidence which can work. They do need still primary evidence. They have to have some letter from them which will say, it can be service certificate, which can say just the end date and start date. which is the common thing we see, that you will just get a certificate of service saying that this person started and ended the employment on certain dates, but does not state any duties or any other skills. So that's where then they will have to go back and get some affidavits from their supervisors or colleagues to meet those requirements. So these are the things we have to keep in mind when we are working on PERM, and it can take some time because we don't want to have these issues later at I-140 stage. That's the stage when we need to submit these documents. So which brings me to I-140 stage, right? Issues we see at I-140 stage. So for sure, if you take care of these issues like education and experience before, then this should not be a problem at the I-140 stage. But still be prepared. It's discretion by USCIS that they will accept your evaluation or their experience letter. They can always come back and ask more. The other issue with I-140 is the ability to pay from the employer, because it has to be shown from the perm date. And if somehow the employer's taxes are not filed or the tax returns are showing some loss, then that could be an issue at I-140 stage. I-140 could be even denied because the employer could not show the ability to pay. So these are the things for I-140. They're going to look if you're meeting the education, if you're meeting the experience and ability to pay. If you do not meet any of these, the I-140 petition, immigrant petition, could be denied. And that, it just all that hard work which has been put all those years just goes. Then you cannot even go to your third stage, which is I-485. For now, since we're talking about issues and challenges, I would say that for I-485, the issue would be that people did not maintain their status or their extensions were not filed at time. And if there was some issue with your status at certain time, that could create issues at I-485 stage. So these are the main issues we see, with different processes of green card through employer.
I appreciate you sharing your expertise on that topic and the common challenges. So once somebody does get through that and they do get their permanent residency, can we talk about how somebody can maintain that and what they need to do to ensure that they can keep it?
Yes. So yes, you got your green card. Now what? So now, of course, you want to be prepared and maintain your green card. Ultimately, everyone wants to apply for citizenship, right? US citizenship. So there is certain requirements which has to be met. But make sure once you get your green card, if it's through an employer, you have to make sure you can work with for that employer because the green card is through that employer, right? So that's if you were not working for them when you got your green card, then you have to join that employer. Because once we are doing this PERM and I-140, basically this process is that this employee will join the employer once the green card is approved. So once now your green card is approved, then you make sure that you're working for the employer who sponsored your green card. This could be looked at when you file for your citizenship. Besides that, make sure that you abide by US laws. They must all green card holders must obey all federal, state, and local laws and not engaged in any criminal activities. Violating of any US laws can lead to deportation and loss of permanent residency status. So that's very important. You do not want to have any such issues. Then you also want to make sure, then the other thing is that file your taxes, US tax returns. This will be questioned at the citizenship stage. Where are you filing your US taxes? Then also important is that meet your requirements as a residency. A green card holder must maintain a permanent residence in the US. This means they have to stay a majority of the time, stay here and work here in the US, not be living in another country after you get your green card. You could be traveling, that's okay, but you cannot be absent for extended periods of time. Specifically, I would say that a green card holder must not leave the US for more than 6 months at a time. And if they do plan to be outside the US longer than 6 months, or if especially 1 year, they must obtain a re-entry permit. If you are outside the US for more than a year, then your green card would be considered abandoned without a re-entry permit. So make sure that if you have to stay outside more than a year, then before you leave the US, you have a re-entry permit. You have to apply for it. It can take some time to get it, so you have to plan ahead for it. But make sure you get your re-entry permit. That will allow you to stay for, you have to come back within 2 years, but at least you can stay longer than 1 year. So these are the main things to keep in mind once you have your permanent resident status. Just it's a lot. It takes so long if we go through all these stages, we did PERM, we did I-140, we did 485. So it's been so many years. And so you want to make sure that you maintain your resident status.
That's very important information to make sure you maintain your residency status for anyone listening. And if you do have any questions, please reach out to your attorney. We're available. We have a lot of immigration attorneys here at Chug, so feel free to reach out to us anytime. That is all we have time for. So this does bring us to the end of our conversation. Thank you so much, Navdeep, for your time and expertise and everything that you shared with us. And thank you everyone for joining us today. If this video was helpful, please make sure to give it a like. And to stay up to date with us and all of the news, please subscribe and follow us on Facebook, LinkedIn, and YouTube. And if you have any questions or suggestions, please feel free to email us at info@chug.com anytime. And join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care, everyone.
Thank you.
Thank you, Navdeep.
Thank you.